As to the provisional ballots, appellant has, I think in their papers, misconstrued or mischaracterized the difference between reviewing and recounting. The 71 provisional ballots that were excluded by the registrar, they were not included in the initial canvass. It would have been entirely bizarre to count ballots that the registrar determined were cast by persons ineligible to vote. It would be entirely bizarre to count those in the recount. There is no wizard's curtain operating here. In fact, the record shows that at Respondent's Appendix, page 369, Mr. Butcher, representing Mr. Feather, actually asked us to produce all of those provisional ballot envelopes. And truly, Mr. Butcher sat down and went through all the envelopes to make sure that we had acted appropriately in excluding those folks who had already voted or were not registered to vote in the election. And if there had been some issues there, I'm sure we would have learned about it. It might have been included on their notice of illegal votes when we went before the trial court. But no such provisional ballots were ever challenged before the trial court. They never made an issue of it. I don't even think they asked for it. And that raises yet another point. If they wanted to, they could have asked for this information. They could have asked for it during the recount. They could have paid for the recount. They could have requested it.
Let me follow up Justice Sill's question that you started with. What do you think the legal significance is for the fact that they didn't?
Well, I think it goes to their parade of growth. You know, this whole idea that, you know, if the court doesn't today order every voter in the future to do a manual recount, then all these horrible things will happen. That's not what will happen. You will, if one candidate in a close election gets the sense that the other side is trying to game the system, they'll step up to the plate and pay for their own recount. And that's all that needs to occur. And that could have happened here, but we, with all due respect, we suspect for political reasons, one candidate tried to frown upon the recount requested by the other in order to score political points, in order to play political relations rather than to actually preserve their rights in court or as necessary through the recount process. So, again, the statute, the elections code, really does put the voter who is requesting and paying for the recount in the driver's seat. And we stand back, and as long as their procedure is legal, you know, whether they request the precincts from Garden Grove before Westminster or Westminster before Garden Grove, whether they want a manual recount or electronic vote, as long as it's legal, we will defer. That's our duty, to defer to their request. We would point, Justice Aronson, that, again, if they had an issue with it, their remedy should have been, if they truly believed that...
That's Justice Aronson.
I'm sorry, and it was Justice Sills' question, but the idea was if they truly believed, if they truly believed that the manual recount was mandatory, then surely their remedy would have been to the trial court, even before the election contest, to petition for writ of mandate. If this is actually required by the elections code, then, you know, let's have it out. Let's resolve that issue there. You know, rather than kind of keep this issue in the back pocket to be played only if the disputed balance doesn't play out in their favor. So, I mean, that is consistent, I think, with the way in which courts should review election contests. You know, there is a presumption that the election should be held valid unless it's plainly illegal. And courts frown upon these kind of technical, procedural, alleged violations of directory provisions that don't really go to the outcome of the election or to the substantive results of the vote. And once the court realizes, once the court comes to the conclusion that there was substantial evidence supporting the trial court's finding, and once the court reviews the legislative history that shows that truly the voter is allowed to choose whether it's a manual count or an electronic vote, then what is left of the case that the appellants now have? It's an argument about how to interpret 19253, but it's not an election contest within 16100. They're no longer talking about an error. They're no longer talking about some problem with the canvassing board. They have no real showing of error. Certainly, Justice Bible, no showing that Nguyen actually won the election. And as we pointed out in our papers, it would be entirely inexplicable for this court to now reinstate that initial canvass. That because of the manual count that was done of the absentee ballots, we know that that initial canvass had undervotes and included votes on the paper ballots that had illegal identifying marks. So as a result of the recount that was conducted, we now have a better, more more precise approximation of the legal vote. And that's what stands, and that was what the registrar certified.